The Supreme Court justices have had another busy week hearing arguments on a number of cases, including one about water rights between Florida and Georgia. Joining us this morning to talk about it all is our Supreme Court Spotlight legal analyst and News Channel 8 associate producer, Felix Vega. Felix, thanks for joining us.
Absolutely.
This Florida-Georgia case has gotten a lot of attention because of the impact that it has on the state's environment, particularly in the Panhandle. Can you explain sort of what's happening?
Yeah, this case has been going on actually for a long time. It's a long-standing dispute between Florida and Georgia over water rights that flow into the Apalachicola River. And so we can take a look at the map, that look at the area that we're talking about here. It's actually two rivers that flow into the Apalachicola River. You see the Chattahoochee River there on the left, Flint River on the right. Both of those meet at the Florida-Georgia line and then flow into Apalachicola River and then out to the bay. What's been happening since the early 1990s is Florida's accused Georgia of taking too much water out of the river basins and storing it for growth inside of Georgia. There's also 5 dams along the Chattahoochee River that have also restricted the water flow. The impact has been devastating to Apalachicola Bay because it's also destroyed the fisheries, the oyster fisheries, and the environment and the ecosystem. And it's had a huge impact all the way down, not only for the fishing industry, but also for the tourism industry. So they want the water to be re-released and flow down into the river. We also take a look at the ecological impact. There's 142 freshwater fish species, 26 mussel species, which include oysters, 1,600 plant species, and 100 endangered animal species in that area that we're talking about. That's the huge impact and why it's an important case that got to the Supreme Court finally.
And that obviously leads to people's economic impact.
Exactly.
People are farming those.
Right.
All right, there were also 2 cases that deal with your constitutional rights when it comes to, it comes to vehicles. The first one was with rental cars and who can drive that car?
Correct. This case actually originated in New Jersey, and it deals with who is an authorized driver on your rental car contract. And a lot of times what you do when you go in, you can have someone, if you're going on a road trip, driving with the family, you can put another person on the contract so that they're covered for insurance. It also affects your ability to basically is to say that you don't want your car searched if you're an authorized driver. In New Jersey, what happened is this man, he had his girlfriend, he was also a convicted felon. He could not rent the car, so his girlfriend rent the car. He then got pulled over in Pennsylvania, and they found 46 bricks of heroin in the trunk of the car. So clearly trafficking and possession of heroin charges came out of that. What ended up happening is he challenged the search, saying that he had an expectation of privacy because the girlfriend let him use the car. The lower court and the appeals court said, no, you are not an authorized driver. You do not have that same protection under the 4th Amendment. What happens is that if you're not the authorized driver, they can search your car without probable cause. That's how it ended up at the Supreme Court. I don't see them extending that protection to unauthorized drivers because of the way the case law has been, and they really don't want rental cars becoming basically harbingers for criminal activity.
Sure, yeah. The other case deals with when police can search a vehicle without a warrant, and this is pretty unique.
Yeah, this is because it involves going onto your personal property, your private property. This was a case out of Virginia where they were looking for a motorcyclist who had escaped after a chase. They tracked him down through social media, found a very distinctive bike that he was riding, and was tracked down to a specific house. They sent an officer out there, but the officer didn't have a warrant, didn't have probable cause to believe or even know that it was the same motorcycle because it was covered up. And so he peeked under the cover, saw the VIN number, saw the tag number. That's the same if someone went into your garage and opened the door without your permission. He could have gotten a search warrant easily, he could have gotten consent from the owner of the vehicle and the driveway. So that's where this case ended up getting set up the way it is. It's important because police can easily get a search warrant and specify where they're going to serve the search warrant and retrieve the property. They didn't necessarily need to go over there covertly and then seize the bike without that authority.
Yeah, you still have a right to privacy.
Exactly.
Let's talk about one case that will likely be headed to the Supreme Court. That is the DACA program. Judge in California blocked the president's decision to end DACA for now. How did he do that?
This was interesting because there's 5 cases that are simultaneously going on about DACA in California. And one of them involves the University of California and former Homeland Security Secretary Janet Napolitano. They wanted to block the end of DACA because the case was simply not going to be done in time. And what the judge did, they put out a bunch of different arguments, and like 4 or 5 arguments he shut down. I'm reading through the order, and I'm like, where does it say that they're not ending the program? He got down to equal protection and their rights under the Equal Protection Clause of the Constitution for those DACA recipients. And basically they said if there is even the hint of discrimination in ending a program that's federally sponsored, then they can block the program from not being ended. And that's what he did. But the key thing, what he did in this case, he also looked at the president's tweets and his comments for that racial animus. And this is one of the quotes that he said from the campaign trail. Are there clear-cut indications of racial prejudice on the campaign trail? Are they to be forgotten altogether? And then he cited the other cases involving the travel ban where they also used the president's tweets and comments. And he said this order will follow those decisions and hold that, at least at this stage, campaign rhetoric so closely tied to the challenge action, which is DACA, ending DACA, is admissible to show racial animus. So the president's words and the administration being used against him in this case.
And there was another case at the Supreme Court you had your eye on. We're not going to get a chance to get to it, but maybe we can do it after the show.
Yep, absolutely.
We'll put that one on social media, folks. Give you a little extra if you like it. All right, I checked yesterday. As of Friday, the court added 12 more cases to the already packed docket for the term. That's another 11 hours of arguments. So a lot coming from the Supreme Court.
Absolutely.
Here.
Very busy term.
All right, we'll be right back, folks.